Hello Legal Eagles, and welcome to Rylands and Fletcher rule, which is going to finish off our private nuisance topic. So the first thing to comment on is the key case, Rylands and Fletcher. We don't really need to know the facts of this case, but it did involve, as you can see in the picture there, a mine. The key thing here we want to take from is one of the judges, Blackburn Justice, said, the person who, for his own purposes, brings on his land and collect and keeps there anything likely to do mischief, if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. So essentially this is the judgment and case that created this area of law, common law. We need to break this down in terms of the key components you'll need to outline in an exam scenario, and then go on to, in your view, claim whether or not a scenario or the claimant has them or doesn't. So we've got here breaking that down into three parts. The claimant needs to prove first that the defendant is using the land for a non-natural and extraordinary use. So it's very important that you don't forget both of those elements, non-natural and extraordinary. Secondly, that the thing, whatever it may be, as we'll see some examples in a moment, escapes and causes a mischief, and that mischief then leads into really point 3, which is damage, but that damage is reasonably foreseeable to the adjoining property. So to recap, it's something non-natural and extraordinary that the defendant has, and that thing that they've brought onto their land has escaped. It's caused this mischief by going onto the claimant's land, neighbouring land, and therefore they've suffered damage as a consequence. So just really wanted to highlight here some of the case judgments and scenarios that the courts have had to face, and whether or not you think this is a natural use of the land or not. And of course, if it is a natural use of the land, there is no claim. So what I'm going to do here is I'll go through each one. If you want to either pause the video after each one or just run along with me, we'll see if you are right in your thinking. So firstly, blocking a sink and toilet which causes flooding to your neighbour downstairs. Would that be a non-natural use of the land or natural? And the courts decided here that it was natural, because that facility on your land, toilet and sink and so forth, and naturally the plumbing and so on that goes with it, is something that is essential and expected of somebody's property. So as you can see that was decided in the case of Rickards and Lothian. There is really no need, I think, to sort of learn these cases that I'm showing you here. I only raise them for the fact that if you wanted to look further and see what the judgment may have been, the most important thing for you in terms of the exam and what AQA expects for paper 2 is that you know those three elements that I've just set out, and that you're able to distinguish between what is likely to be natural and non-natural. So the second one is storing a large quantity of water, enough to fill a reservoir which floods your neighbour's land. Natural or non-natural? And the answer is non-natural. So this was, very much what Rylands v Fletcher case was about. And in this situation, what makes it non-natural and extraordinary is it's a large quantity of water, as you can see, and that's something that we can both agree is not natural. And then we have manufacturing goods, so factory. In this instance, they're manufacturing metal foil on an industrial land, and that gets blown, escapes, and gets blown onto an electricity substation nearby, causing a power outage to your neighbour. Would that be natural or non-natural use of the land, these goods? And the answer is natural in that particular case. It's quite a famous case alongside Rylands and Fletcher for this topic. The key thing here really is the fact that it was an industrial land, and so the manufacturing of such goods in that context would be natural. Then you have here, you run a chaeroplane roundabout at a fairground, so as you can see there, you sit in the chair and it goes round and round. One of the chairs comes loose and hits a person, injuring them. Is that natural or non-natural? And of course the answer here is it's non-natural, according to the case of Hale and Jennings brothers. So that was something that clearly had to be brought onto the land. It doesn't otherwise belong there, and really fits the criteria that we're talking about. What if you have a scenario where you're lighting a fire in your rented house and a spark emits from the fire and starts in its own right a fire? Would that be natural or non-natural use? Now many of you might be thinking, well, fire is quite a natural thing, isn't it? And it's quite an expected thing to have, perhaps, and you'd be right. So I know there's various ways you can heat your house today, but of course people, some of them do still light fires, and a bit similar to the toilet one and so forth, the courts weren't prepared to find that as a non-natural thing. You then have a local authority water pipe bursts and seeps onto neighbouring land, causing a sinkhole and exposed gas pipes. Do you think this is natural or non-natural? And the answer is natural. Again, I think the court's very clear to distinguish between what is, fundamental facilities or sort of aspects of the land that really people need, and they do not want to find against them, because of course to do so would lead to a outpouring of claims to the court. So just looking a little deeper here, the thing escapes was one of the components and causes a mischief, and here the defendant has to have this thing initially within their control, or indeed it's sort of occupied by them, and then obviously the thing escapes onto the adjoining land. And key case here is Reed and Lyons and Co Limited, quite an old case, but here it was to do with munitions. The claimant was injured by an exploding shell on the defendant's premises where they were being made, but no liability as it was still on the defendant's land. So the thing, although it escaped, it hadn't escaped the defendant's land. It has to escape onto the claimant's land, and that's a key thing, and why here the courts weren't prepared to accept a claim. And also you might be thinking, why was this being done? I'm sure eagle-eyed people here have noted the year of the case, 1946, so really this was the Second World War, or just coming to the, well, I was going to say it's the end of the Second World War with Europe, but of course it was still continuing with Japan. One thing you will need to do for me is complete this table. So just on the left hand side you've got types of remedies that are quite sort of specific. Oh, did I say types of remedies? I do apologise. Defences, I'm going to change that now. Type of defence. I like capital letters. There we go. Alright, type of defence. Act of a stranger, act of God, statutory authority, valenti non fit injuria, otherwise known, as I think more commonly by us, as consent, and of course if there is consent when we deal with negligence, then as in previous topics there is always contributory negligence as well. So at least two of these you would know, and I think actually to help you, to be fair, I should just put consent there, shouldn't I? Just to make it clearer. There we are. Okay, so that is something that I need you to complete. You can use your textbook. Of course, I'm going to cheat because on the next bit here you've got the answers. And again, I just need to change that table, don't I? Type of defence. There we are. So just to run through. Act of a stranger. Pretty much what it says, if the thing escaping, whatever it might be, is due to the act of some third party that the defendant is not aware of, then it's not going to be their fault. Act of God, particularly extreme weather conditions, but it's something that is not reasonably foreseeable. So again, I'm thinking about, off the top of my head, I can't remember the exact year now, I don't know if it was 86 or 87, but the great storm in the 80s where the weather person on the news basically said, it's going to be a slight storm, don't know really what everyone's going on about, we'll be fine. And then we woke up the next day to overturned trees and a huge amount of damage and whatnot. So things like that. Statutory authority, again, this is something where, I think we have touched on this before, is only in situations where an Act of Parliament authorises that particular sort of activity. So I guess we look at the previous example of the munitions one, may very well have been, I think, an Act of Parliament would have allowed the building of those kind of things for the war effort. Then had it escaped the land onto the claimant's land rather than just left on the defendants and we said there was no claim, perhaps this would have been a defence. Valenti non fit injuria, that we've just said, is consent, and that's I think we've covered that before, so I won't go into too much detail. And the same for contributory negligence. So that's really recognising that a degree of fault lies with the claimant as well. Situation there could be, I'm just trying to think, so something that they've done, maybe they've erected a fence, the claimant, and the fence is in really poor condition, and so therefore that's why I don't know, a herd of sheep decide to escape onto the land or something like that. So in that situation the court would recognise that and reduce the amount of damages that the claimant could achieve. Also need you to complete this table, and this time correctly it is the type of remedy. So this really finishes off, as I say, private nuisance as well. You've got damages, you've got an injunction, and I think also more so for Rylands and Fletcher you've got abatement. So if I switch that, here's our table. We know damages is compensation. It's really trying to attempt to place the claimant back into a position they would have been had they not suffered that loss or injury. Injunction is that court order we've been referring to up till now, which the court can use to prevent the defendant from actually undertaking a particular activity, or it could be undertaking that activity at a particular time or day, so there can be conditions attached. And abatement is an order to enter the defendant's premises in order to prevent further nuisance, so it could be quite useful if the problem doesn't go away. Scenario then, and there is only one this week for you to consider. So I've put here, Jonathan is a tourist enjoying a walk in the countryside. Returning from the local village, he opens a gate but fails to secure it. Unknown to him, a local bull owned by Farmer Paris is in the nearby field and escapes onto the adjoining land of another farmer, Giles. The bull destroys his prize vegetables, so it's for you to decide here whether or not there is, if you will, going to be a successful claim by the defendant. I think essentially that's all there is for this scenario, so I'm just going to leave it there and say thanks very much everyone, and I look forward to your answer to this scenario, which of course you can email me.